Hey, this is part 2 in the series of examining the collection lawsuit. And this is part 2, as I said, the complaint. I want to give you a quick tip from my last one that it bugged me that I didn't tell you this. When you are served personally, a process server is thinking all the time, am I going to have to defend this service? And his client maybe too. So they will hand you the process server and ask you to sign it, because it makes their job easier defending themselves if there was something flunky about the process service. I don't know of a law that says you have to sign that. And funny enough, during COVID, I tell my clients, do not sign anything. The guy's handing you a pen. So don't help anybody that's trying to sue you, so you don't have to sign anything. If they're suing you, make it as hard as heck for them. Don't avoid service if it's right there and you close the door. But you don't have to sign anything. And I wanted to tell you that for the last video. This video, part 2, let's put up the same case that we're examining, and let's put up the first page, Shazam. So as you recall from that last case, my client had been served twice, once in a county they didn't live in, and now this lawsuit. And as you can see, right in the middle of it, it says, pursuant to, let's say MCR 2.113C2, there is no other pending or resolved civil action arising out of this transaction or occurrence alleged in the complaint. Well, from my last video where they clearly had been sued previously, that's a false statement. So right off the bat, that's something you can use to build your counter affidavit. It has a caption, and that's hopefully saying the district that you're actually in. Look for that. Paragraph 2, that's telling the court, hey, we're suing in the right place, unlike when they did it previously. And here's the address. So look at number 4. Let's blow that up. Number 4, Shazamski. Are there any mistakes here? Well, there's a lot. They're saying they are the original creditor PayPal credit. That's not a creditor or name of any company. Go Google it. Partnered with Synchrony Bank. That may be the original creditor, but the way they've said it is false, so that's going in your counter affidavit. And then they continue on and they say, defendant has never provided plaintiff with any written or verbal objection to any of the statements. As you recall, this is a case where they sued him previously in another county he didn't live in, and now this is the second lawsuit. So that's an out-and-out lie. They know because they were there when he was yelling at them and the judge about, why am I being sued in a county I never lived in? And he won that motion. Judge agreed with them. So they know that. There's actually a court document saying that's a false statement. So you've got to look at these things. They're important. They are claiming, let's put up paragraph 1, Shazam, I skipped over that. This may seem innocuous, and I think that means not important, but that may not be true. Google, do a Google search. A lot of times, like there's a particular company, and I'm not going to say it, but it actually moved its operations to a different state, yet it was still using the allegation that was in the state of New York. Well, that's a false statement. It's another brick as you build this beautiful wall. If they lied here, they lied there. It's all about credibility, my friends. It's all about credibility. So check that out. Use Google to see even the most silliest things. Where do you live? Where do they live? They've got to rightfully say why they're suing you, where they're suing you, and they can't lie doing it. In this case, as you see on the first page, there's your old friend, the mini Miranda rule. That's great. No, you can't do that. No debt collector does that and sues, because it turns the collection complaint, which is never a collection attempt or communication, into, well, let's just see. It says it's a debt collection information. They're collecting a debt. So there you go. They just screwed themselves, and they lose immunities that they normally would have. And we've talked about why they do that. See my video, How Creditors Become Debt Collectors. And we've got lots of debt buyer and creditor videos. Just take a couple. There you go. Boom. So My client had objected to this lawsuit when they had defaulted him. So he has a court record of this lawsuit being false and the fact that he never objected to it. You also see that he's being sued on an account. What's an account? An account is normally somebody owns something and there's an accounting. So it's not a debt because it would say right here they're collecting on a debt, which they do not say. And we've talked about securitization. So you need to look into words. I've actually put many of my MCM videos, if you look at Midland Credit videos, there's a couple of them, Shazam. They will talk about, here's the definition of an account, here's a definition of a debt. The FDCPA, which regulates collection activity of debt collectors, does not have a definition of account. So why is the word account there instead of debt? Because they're debt collectors, right? Or they're debt buyers. Because the debt is long gone in the securitization process and all that's left is an accounting or a servicing. So the person suing you, if it's a creditor, is really a servicer. They don't own the debt and have no standing to sue you. Here, it messes up the chain of title, which will be in our video 3 of this series. So words matter, my friends. So do lies, so does credibility. You can look at the last page. It really is a nothing burger, Shazam, and that is just doubling down on something that wasn't true in the first 12 allegations that they made. But examine every word. Here's a good examination. Number 14 says, by virtue of the circumstances surrounding the request for funds made, comma, defendant knowingly requested the funds at issue and or knowingly and voluntarily accepted and or received the benefits bestowed. That's utter nonsense, okay? Put that in your answer and put that in your counter affidavit as you build your counter affidavit. If it's utter nonsense, say that, because anybody reading that goes, I have no idea what's going on, and the purpose of a lawsuit and the summons is placing you on notice of what you're accused of. I don't know what anybody's accused of and by whom, but again, my point is look at the words. They matter. They say nothing. So just bear in on their defects. You'll have your next video, which will be examining the bill of sale and assignments, or in this case, the lack of. And this concludes Complaint Examination Part 2. Thank you.